of Texas. The borrower, I bought it on a wrap, and I am obligated to make payments on the underlying. I feed GPT a lot of information, but it is faster for me to do this and cheaper than for me to call an attorney. And by the time I get all my learning done with GPT, then I can go take it to an attorney. So I want you guys to remember this. You can save yourselves tons of time and money by learning to do this. So my wrap buyer has failed to make the last two payments and is refusing to pay any more because of a dispute about record keeping. The disputed information is trivial and I don't see any reason. Now, because this is a consult, I'm going to keep some specific details out for you guys that are watching. But any reason they would have grounds to refuse to pay the monthly mortgage. The buyer continues to refuse payment until their dispute, which at most is several $100 and a name change on the account, is resolved. Since this is in Texas, and since since the existing mortgage, I bought this sub 2 from the original borrower. What options do I have? What challenges can my buyer bring against me? Note, I do not sell on wrap mortgages often, and RESPA doesn't apply to me in this case. The dispute is regarding RESPA compliance. I don't disagree that the requirements imposed on lenders by RESPA are reasonable. But I am also not obligated to comply. The borrower's attorney assumes I'm I'm regulated by RESPA. And let's see what it comes back with. Oh, note, there is little equity. The borrower has been paying for just over 1 year on a 30-year note. And when I bought the property, now you could do this via voice if you wanted to, voice typing and voice communication. But when I bought the property, I was only able, it had no equity, and I was only able to sell it for a 10K markup. So overall, there is little room for profit here, and I didn't mark up the interest rate. Can I just pause and make eye contact with you guys? Look here, right here, binoculars. Don't do wrap deals for less than $400 a month. You heard? You heard, fam? Don't do that. They're just not worth it. All right. Let's see what they got. It's going to be, I'm going to scroll out so I can see what it types. I made this small for you Instagram types, although Instagram has the most viewers compared to other sites, so I do want to cater to that. You guys are welcome to ask in the chat. Options for addressing non-payment foreclosure. And the reason I stuck on Texas is because Texas has fast foreclosures. So I'm going to start my response. What I do with ChatGPT is I look at it and I start my response down below as I read it, and so that way I can catch my thoughts instead of reading through 4 paragraphs and be like, what did I think about the first paragraph? So what I do is I'm going to say foreclosure. Yes, foreclosure in Texas is pretty fast. My concern is that I could catch a due on sale by initiating a foreclosure. A due on sale from the underlying lender by initiating a foreclosure. Oh, all right. So 1, I do these little 2, I do it like this. I number all my issues. Is that likely? Number 2. What is number 2? Remember, I haven't read the rest of the response. I'm still stuck on the Texas foreclosure piece. Can I bid the amount due to me at the auction and get the property back? If I do so, do I have to pay the underlying mortgage off? Or is there a chance I can bid my borrowers? Is this slow and boring? That's what the job is. It's a pain. Can I bid my borrowers remaining balance and continue payments on the non-defaulted, non-monetary defaulted? Technically, we did default when we sold it, subject to. Okay, next. Non-judicial foreclosure, notice of default, acceleration. Oh yeah, 3. What's the timeline for something like that? I have evidence. I have not begun sending default notices that comply with federal and or state law for foreclosure. Number 4. Now, legal negotiation. Offer to clarify your non-RESPA status. Pointing out that RESPA may govern traditional, but does not apply to private wrap transactions where you aren't acting as a traditional. Well, that's worded incorrectly. See, this is where you need to know your stuff, number 1. But number 2, it's not just the fact that you're not a traditional lender. It's related to your volume. This person only did 1 of these. You could also propose a neutral resolution. Well, duh. Mediation. Well, duh. All right, so that's basically duking it out with third parties. Challenges they can bring. RESPA compliance. It doesn't apply. The attorney may attempt to muddy the waters by arguing that similar protections should apply. That's reasonable. That's a reasonable attack, I think. This could cause delays if they attempt to take it to court, and even though their claim is weak, Texas courts consider equity in determining foreclosure outcomes. Although equity is minimal, the borrower argues they contributed to the property and are entitled to protection. It might complicate the foreclosure route. Public relations. Okay. Judicial foreclosure offers the most straightforward path. Okay, so that's my 3 questions. The borrower's challenges are pretty weak. Available challenges based on the information available to us. Due on sale clause trigger. Initiating foreclosure could indeed attract attention from the underlying lender and potentially trigger the due on sale clause. However, lenders are typically more concerned about receiving their regular payments. All right, so this is just reading off the internet and getting the sentiments from people who are purporting that the due on sale clause is not scary. If you stay current on the underlying mortgage, the lender might not take action. Also, if the property goes to auction and it doesn't have enough equity, the other bank is going to inherit the thing. So it's a complicated spot. We really don't want to trip due on sale here. If there was enough equity to refinance or sell, then it wouldn't be such a big deal. Bidding your borrower's balance at auction. In Texas, the lender initiating the foreclosure, you can bid up to the remaining amount your wrap borrower owes. If you win by bidding, you would regain control of the property without needing to pay the underlying mortgage in full immediately after regaining ownership. Now, this is what I don't know for sure. So this is what I would want to take to a Texas foreclosure attorney. Is it foreclosure attorney? I would want to find an attorney that understands this sort of thing. You can continue making payments on the underlying loan, assuming the other lender doesn't call it due. Okay. If a third party wins with a higher bid, they would need to address the underlying mortgage. Yeah, so if somebody comes in with a bigger bid, that's a cash payment in full only. And the only time somebody else wins is if they bid more than the borrower owes me or my client in this case. So if I bid what my client owes me, I'm sorry, my borrower owes my client, if I'm my client. Let me start that over. I'll just be the client. If I bid what my borrower owes me, then I'm basically going to take the property back. But if somebody bids more than me, then great. They pay off the underlying loan and me. Timeline, 60 to 90 days from the first notice to the auction date if you move expeditiously. You send your notice, giving 20 days to cure. You give a notice of sale. Now, what is a common tactic people use, even fraudulently, to stall foreclosure auctions? They file bankruptcy. Yeah, so far it's helpful. All right, what did I want to call BS on? I want to make sure. I'm going to copy this. I want you to act as a real estate attorney who also manages foreclosures in the state of Texas. I'm being told, blah, I pasted it. If you win the auction by bidding only that if I take my borrower, if I foreclose on my borrower, if you win the auction bidding only amount due to you, you would regain control of the property without needing to pay the. So, all right, let's use example math for the scenario. The underlying note balance is 200,000. My wrap borrower note balance is 208,000. So, is it true that if this goes to foreclosure and I bid 208K, ignoring legal fees, the property will become mine, and since I'm the winner, I don't need to bring payment to satisfy the auction bid. In other words, I don't have to bring any funds or certified checks, etc. I just have to have the winning bid. And I'm not required to liquidate, pay off the underlying mortgage, which never went into monetary default. This is what's dangerous about these low equity deals, is you're playing with fire a little bit here. As your role, that was the attorney, please advise me if that's what's likely to happen. Feel free to ask clarifying questions so you can give me the best response. Let's see what we get. We're using GPT to help figure out how do we approach some really complex stuff in the state of Texas. Okay. Bidding the amount due on the wrap loan. As a lender in this foreclosure, you are indeed allowed to bid the remaining balance owed of 208. This example money. If this is the highest, you would win the auction. No cash requirement. If you're the winning bidder, you wouldn't need to bring cash or certified funds to cover it because the amount represents a debt owed to you. You don't have to bring money to pay yourself. Technically, the lender already fronted the money for the deal. Now, in a wraparound situation, you didn't front the money. That's why I'm asking here. This essentially means you're offsetting the auction price against the borrower's debt rather than having to pay out of pocket. Since your underlying mortgage is not in monetary default and the lender hasn't called the due on sale clause, you would not be required to pay it off immediately. You can continue making payments on the original note, treating it like a subject to. So this would generally be true of second position lenders as well. That's okay. So that's my question. What if this were a slightly different scenario? What if I was a second position lender and wanted to foreclose for monetary default on my note while the underlying mortgage was current? Let's use the same balances. 200K underlying and 8K as my second position. Is my auction price 208K or 8K? And if I bid 208K, is it assumed that I'm paying the underlying mortgage off as a result of winning? Or can I take over the property subject to that loan? Okay, still reading the response. I just wanted to craft that follow-up question. You can continue making payments, great. Potential trigger due on sale clause, yes, we understand that. After the foreclosure sale transfers to you, extinguishes the wrap borrower's interest in the property, great. 208 bid would satisfy the foreclosure requirement without cash outlay. The 208 bid settles the debt from your borrower to you, and you regain property control, ownership, etc., while continuing to service the 200K underlying mortgage. Okay. Acquire, avoid obligation to pay off. Feel free to clarify. Okay. So let's ask my question. What if this were a different scenario and if I was a second position lender and wanted to foreclose for a monetary default while the first position loan was still current? The foreclosure process and outcomes differ significantly from a primary wrap scenario, so let's walk through. Only the amount owed on second position. In Texas, when a second position lender forecloses, the foreclosure sale only addresses the amount owed, $8,000. First lien remains in place as unaffected. How does that work? Well, so your effective bid is still 208. This says as a second position lender, you can bid the 8,000 owed to you, which makes sense. But if you win, you would acquire the property subject to the existing 200K. So this foreclosure is only on the second position. The foreclosure is to affect title transfer, but it's only for the second position lien. And you would be taking it subject to the existing 200K first lien. Is that true? Huh. If they bid more than 8,000, that's fine because that would pay off me and the underlying mortgage. Wait, would they take it sub to? Oh, they would be buying it subject to the 200K first mortgage. Okay. In an auction like that, how are the bidders made aware of the existing first position, its balance, and its terms that they would be taking subject to? Do they really bid on the 8K balance for the property? Or are they bidding against the 208K balance? Okay, continuing on to read. Winning the bid does not mean you're automatically paying off the first mortgage. You're instead taking ownership of the property subject to the lien, the existing 200K. Okay. You can then make payments as if it were sub 2. Auction price is based on your 8K second position loan, not the full 208. Winning bid outcome, you acquire the property subject to, if you win, no automatic first lien payoff, loan payoff. Winning the auction, even with a higher bid, does not pay off the underlying mortgage. It simply gives you ownership with the first mortgage intact. Wait. So if they bid 9K, they take over the property for 9K with the existing mortgage intact? All right, so two questions. Number one. Number two, if the under mortgage, am I required to notify the underlying mortgage of the auction foreclosure resulting from my defaulted second position? 3, can the first position lender accelerate during the foreclosure process, and would that be material information for bidders? Let's see what it's got to say now. There's a couple of people still watching on Instagram. Is this interesting? This is what I do to learn stuff, and then you guys see the results in Facebook when I comment on stuff. It's like because I've spent hours having conversations like this. At foreclosures, it's generally the responsibility of potential bidders to perform their due diligence. This includes checking title records. Ooh, how are you going to check the balance of a first position mortgage? Technically, they're bidding against the 8,000 second lien balance because that's what's being foreclosed on. But if they don't understand the balance of the underlying mortgage, it's a lot more likely that I'm going to win my own bid if that's my goal. Yeah, well, they might also bid. Somebody stupid might come in and bring, 26,000 or 140,000 cash, buy the properties, golly. Wait, so if someone bid 146K, where does that money go? 8K to me, and the remainder to the defaulted? Okay, notification. Notifying the underlying lender. There's no obligation to notify the first position lender. However, if they discover it, they can choose to do on sale. Sure. Okay. Hmm. Good to know. What did we learn today? A bunch of stuff. Bunch of interesting stuff. Okay, well, that was the summary. Any comments or questions? That was the summary of what I've got going on here and what I wanted to go through and learn today. Learned a lot about it, and that's great. I can have a meaningful conversation with someone. Now, I'm going to take this back to my client, let them know what their options are, what it would look like if they chose to foreclose. Oh, yeah, let me ask real quick. What is the typical cost to foreclose in the state of Texas? And timeline. Timeline, 60 days. You send those cost. A few hundred to a few thousand. Often under 5,000. Beautiful. It looks like we're going to push that route and threaten the borrower with foreclosure. Not just threaten like blackmail, but like threaten as in you're giving us no other choice. We're going to have to do this. And you can fight that. You need to pay your mortgage. We can continue this dispute about paperwork, but the the not paying the mortgage has to stop now. That's what I think we're going to get down to. Helpful? Hopefully. Okay, that's it for me. Peace out. Catch you again later.